Rajiv Bharti essentially wrote a story on an acid attack survivor. Deepika Padukone's movie follows the life of an acid attack survivor, and there he claimed Mr. Bharti claimed that there were some similarities between them, but in a very interesting twist to the case was when the renowned Mr. Gulzar filed an affidavit saying that, very rightfully saying that there can be no copyright on real world events. And a story like something as horrific as acid attacks happen, unfortunately, all too often in this country, and no one person can truly co-opt that. Um, so let's get started with the PPT. There's something that I wasn't able to visit yesterday that I'll just briefly touch upon first. I'm sure you guys have seen all of these symbols at some point or another, based on packaging, on a brand, on a hoarding, or on a company's board. So what do these symbols mean exactly? The C and P essentially stand out as being copyrights and patents. Patent, the P in the circle, is granted after a patent application is accepted by the patent office on an invention that it deems to be novel, new, capable of industrial application, and is valid for a term of 20 years, meaning that if you are granted a patent on an invention that you try to claim, you get the right to attach this symbol to tell the world that, yes, you have a registered patent application. The C, on the other hand, is a bit more fluid. As we'll find out today, copyright in any work, in any creative work, does not require registration for it to get protection. The copyright, the C in the circle, can be added by you, by the artists among you that finish a painting and want to put it up online. You're at full liberty to put that C to tell the world that this is your original work and this is all ownership of it belongs to you. Once again, a copyright does not need registration for it to uh, avail protection under the law. Now, what about the R and the TM signs? This is where it gets a little interesting. In the course of trademarks, which is, when businesses go head to head with each other, trying to fight over identities and brand distinctions, distincting themselves from each other, the R essentially is added to the brand name to denote that an application is under process of registration or that it's registered completely. But the TM, on the other hand, the trademark, is sort of like the copyright, where people that are confident in their brand identity sort of broadcast to the world that this is their trademark. But when you see the TM, know in your minds that it's not final. It's still under deliberation at the trademark office. It's still going over the files, and a final binding trademark allocation has yet to be made. Whereas if you do see the R at the end of the name, at the end of a logo, at the end of a brand catchphrase, be rest assured that they've gone through the whole works, that they've gone through the process of registering their trademark, and they're sitting comfy on the knowledge that they're safe. They're protected under the law. Now, I had a few pictures, but I'll get to them in a bit. So let's just jump into, where we left off yesterday. Now let's review real quick. All right. Copyrights are recognized for original works of either literary, musical, dramatic, cinematographic, sound recordings, and computer programs. The rights in copyright are negative. They're exclusive, they're monopolistic, they're multiple, and they come in a sort of bundle. So just to review, what do they mean by negative? A copyright essentially stops someone from doing something that only you can do, whether this is make copies, whether this is distribute it, sell it, license to someone, transfer it. It is negative. It stops someone from doing something that only you can do. They're exclusive. They are yours and yours alone. However, if there are more than one distinct creators involved in the work, say like in a group film project, if all of you split the cost of making the film, you're all producers in the film. And hence we'll be able to claim the copyright together. But this is still exclusive to the world at large. No one else in the world is or ideally should be able to use it the way you do. What do you mean by multiple neighboring? They come as a bundle. You don't just get one aspect of copyright. If you get a copyright, you get a whole buffet of rights. So say if you're an author and you've made an original literary work, you get the right of reproduction in a hardback format, in a paperback format, you have the right to make a dramatic play out of it or a cinematographic version. You have the right to translate it. You have the right to adapt it however you see fit, to abridge it. You even have the right to performance. So all these come under the purview of copyrights. And when you're granted it, simply by virtue of having created it, so you're safe in the knowledge that you have all these rights at your disposal. Now, what is essential in the acquiring of a copyright? How do we distinguish, one person's work from another? What is essential is that the creator must have bestowed sufficient judgment, sufficient skill, labor, and/or capital. Now, it is truly immaterial whether the work has artistic merit or not, whether it's profound or foolish, whether it's accurate or factually inaccurate. Copyright will protect the skill and labor employed by the author in the production of his work or her work. So in this way, the law truly understands that beyond the realms of subjective tastes and what people might find palatable or not, what matters truly is the efforts taken into bringing these ideas into reality. It doesn't matter if it looks good, if the painting or the artwork looks good, or if this literary work reads well, or even if it's just a half-decent bunch of squiggles on a canvas. It's still worthy of protection by virtue of having taken that skill, that exertion of labor, that extra special something of human creativity that sets it apart from others. So this sort of ensures that outside the realm, like I said, of subjective taste, that when you think of literary work, it's easy to think of a book or a magazine or a newspaper or like a periodical. But it's also important to remember that in an example I mentioned yesterday, stuff like logarithmic tables that we used in school also count as literary work. They're a collection uh, of facts and digits that are assembled together. Telephone directories, like I mentioned yesterday, those are also considered literary works. You're not going to sit and read through it and marvel at its brilliance, but it's still taken the publisher sufficient time, sufficient energy, and some application of skill to collate all this data and to summarize it and present it in a unique way. And that entitles it to copyright protection. It is important to understand that the owner of a copyright, be it you or anyone else, cannot exert monopoly over the subject matter of that work. Anyone can come to this similar ends using, say, common sources and will be granted a copyright. Now, what do I mean by this? I mean that if you paint a cherry blossom tree and you sell this painting for millions, can you really, in all good faith, stop another painter from painting a cherry blossom tree and selling it for millions, saying that you have a copyright because you've done it already? It doesn't work that way. It's in the expression of it. It's in the unique expression of it. And as we'll see later, there's a lot of fine details to this. Now, I said anyone can come to similar ends using common sources and still be granted a copyright. But this is provided that their work is also done independently, that they arrive at it at their own exertion of skill, labor, capital, and that it satisfies the requirement of originality. So what does originality mean? What does original mean in copyrights? Now, in the copyright context, it does not mean that the thought or idea itself be literally new. As I'll keep saying, it is in the expression of a thought that matters. Think about it, that when truly original thoughts are few and far between, everyone is influenced in some way or the other. We all are. Even the greatest political thinkers, Socrates, Plato, built off the foundations that were laid by their teachers. But they still are considered as contributing to original thought, to developed thought. This is because it's not required that the idea itself be completely unthought of before. That is sort of something that's required in a patent sense. When you're going to file a claim over an invention, in that case, it has to be new. There has to be something novel about it. But in the copyright sense, it just has to be unique. You can use the same common sources. Like I said, you can still look at a cherry blossom tree and interpret it in your own way. That you cannot claim the cherry blossom tree to be your own intellectual property because it's something that's commonly enjoyed by everyone else. However, if a painter was to look at your painting and reproduce it color tone, then we have a problem. Now, let's get back to originality and what I mean by it. Let's take the example one of the students gave yesterday about the Young Sherlock Holmes series by Andy Lane. On a first glance, it rips off the idea of Sherlock Holmes by Arthur Conan Doyle. But as I said, in the literary work context, which is what we're starting off with, what is looked at is the expression of the thought or the idea. And that should differ from literal copying from. So over here, Andy Lane takes up Conan Doyle's idea of the hotshot London detective, and he extrapolates that idea to the character of his childhood. And he builds a whole world around it, and he builds a whole series around it. Now, when you look at it, this is the application of original thought, of skill, of labor, and judgment to a pre-existing body of work without copying from it. Sure, being inspired by it, sure, borrowing certain themes from it. He took characters. I'm sure he referenced Mycroft. He referenced his parents growing up in whatever small village he grew up in. But that doesn't mean that he's infringing on Conan Doyle's ideas. He's simply using that as a launch pad and applying his own creative thinking to it and coming up with something completely new. And that's perfectly all right. The same thing works in Netflix's Holmes adaptation, Enola Holmes, which is just adapted to the film context. Now it's the application of these four ingredients of skill, judgment, labor, or capital is what sets inspiration apart from infringement. To take the raw material or the central idea that may already be copyrighted and exert sufficient creative enterprise onto it to create something completely different from the original. Now, the same principle can be applied to adaptations, which is what Enola Holmes is. It's an adaptation of a literary work for the screen. So the adaptation itself becomes a copyrighted work, as long as it contains sufficient rearrangement or alteration. Now, this also applies to genuine abridgments. What is an abridgment? An abridgment is a condensed version of a usually long and long drawn piece of literature that most typically was written in the old days when grammar was a lot more flowery, and that's sort of condensed for the modern tastes. It still requires learning. It requires apt judgment to create a version of the original that is the same, but through sufficient effort and skill is made anew. But remember, just merely retaining certain passages and cutting others out does not count as a true abridgment. It requires sufficient working. It requires a sufficient scholarship of the text to be able to carry out an enterprise of that endeavor. Now, what about translations? If you were to apply these concepts, would you say that a copyright would exist in a translation of a copyrighted work from one language to another? What do you all think? Should it? Yes, no. You have React emojis, guys. Please, I'd be happy to see them. The answer is yes. A translation does require sufficient skill. It requires a lot of skill. It requires a knowledge of another language. It requires an application of judgment. It requires an application of labor to literally translate everything from one language to another. So if you were to take a language, if you were to take a book in, say, Kannada language, and if you were to translate that into English, yes, to work the ideas, the central themes belong to the original author, but you exerted sufficient skill to bring it into, to make it available in a whole different form. And the copyright will subsist in that new form. Does that make sense? What about dictionaries? That sort of comes under the same view as the telephone directories, where you have sort of in unarguable facts. These are words with very set meanings. But it's simply a compilation of the list of words in a book form. Would you say it's worthy of copyright protection? Absolutely yes. Because it still takes Merriam-Webster, it still takes Oxford, it still takes Cambridge, a sufficient amount of skill to collate these words, to add new words all the time, revise them, update them as per their evolving use in reality. And yes, so dictionaries would be worthy of copyright protection. Now, what about the musical context? If you remember, in music, the copyright exists in the graphical notation of the music or the person that composes the music, and not the words or any action that may be intended to be sung, spoken, or performed with the music. As such, even adaptations of musical works are entitled to copyright protection. If you take an existing melody and you add sufficient arrangements to it, you add harmonies, you change up the rhythm, and you come up with a whole new song based on the original, you have a new piece of art that's copyrighted. Now, this is both unfortunate. It's a good thing and a bad thing. It's a blessing and curse because it is what unfortunately or otherwise allows Indian producers to sort of draw up these old-time classics and remix them to heaven come. And this applies to DJs and radio jockeys too. There is a sufficient exertion of skill to take something that's old and update it for the common tastes, for the modern tastes. Now, I must reiterate that the song itself cannot be copyrighted as a whole, but the music that has been composed of the song will be protected. And the words, if any, will come under the literary context, and they will be afforded a literary copyright. But in the case of, say, a Bob Dylan or a Leonard Cohen, who write, play, and perform all their own music, the copyright of all of them will subsist in them. They'll have the literary copyright for the words of the song. They'll have the musical copyright for the composition of the song and its multiple arrangements over time. Now, what about the artistic context? Art, under the Copyright Act, involves a whole bunch of iterations. As per the definition, artistic endeavors under the Act include paintings, and they include sculptures, any drawings, or any diagrams. And this includes maps, charts, building plans, even engravings, and works of architecture, and works of artistic craftsmanship, like your carpenter that comes and carves a lovely wood paneling for your house. They all come under artistic works, and they're all subject to copyright protection under the Act. Again, depending on the amount of originality presented through the work. Now, notice that the Act includes engraving into its protection. What does an engraver do? He's essentially a copyist. He takes inspiration from what you give him or what he sees, whether it's a picture or a specific word, and he copies that design from the picture and presents it on into metal or stone or some other material based on whatever form of inspiration, as I mentioned. But in this case, even though the engraver copies from a set picture that might be copyrighted by itself, the finished engraving is still entitled to copyright protection. As I said, the act recognizes the value of skill and labor involved in bringing a new work of art to life. So copying from an engraving, interestingly enough, will be considered an infringement of copyright. But an engraving made by copying a picture would not be subject to copyright. Alternatively, if a painting is entitled to copyright, if and only if there is an original turn to it, it cannot be merely a copy of another painting. So kindly note, a painting is only considered if it's on a tangible surface, an acceptable surface, like canvas, wood, paper. Faces do not count. What about a photograph? As mentioned, it is also considered an artistic work entitled to copyright. So the act says that this must originally have been taken by the photographer to be entitled to protection. For it to be an original, certain investment of some degree in skill and labor must be evident. Let's take back to the common inspiration. Take, for example, a photograph of the Gateway of India. A particular picture taken at a specific point of the day at a certain angle, a distinct angle with unique settings, is subject to copyright. But this cannot and does not stop another photographer from going to the same point using at a different point at a different time of the day, using his own settings, but taking a picture from the same angle. He is also entitled to a copyright protection. But a photograph of a photograph does not count, and neither does a photocopy, the Xerox. What if when it comes to taking pictures of a particular individual or individuals, when specifically asked to pose for a photograph, like celebrities at a party? Over there, the prior permission of the posers will be required to publish the image, even though it is a work of the photographer himself. The subjects then are given a certain validation. They're given a say in what happens with the work. But taking a photo of a crowd, say of the multitude of people that flock to the Gateway of India to give company to the pigeons, would not need such prior consent. Now, after a brief foray into Bollywood's ethics and morals yesterday, what about cinematograph films? In the act, a cinematograph film is held to be the creation of the producer, not the director or the screenwriter. But while the act defines films by standards as old as the word sounds, later rulings by courts have brought in videos, television programs, and documentaries under the purviews of film. Where does the originality in this aspect come in? A television report or a documentary may be based on a live incident, something that's happening right now, or a newspaper report, or a specific set of incidences that happened a long time ago. But the act does not prescribe any specific level of originality in films to entitle them to protection. But as we saw in the case laws yesterday, it will deny protection if any substantial part or any aspect of the film has been copied from another film. It is also, as a side note, it's interesting to note that from 1957, when the Copyright Act was established, all the way to 1994, performers in a cinematograph film were not entitled copyright protection. It was an amendment that was brought about in 1994 that recognized what is termed as performers' rights, and finally gave the actors, the stagehands, the background actors, snake charmers, jugglers, acrobats that would normally contract directly with the production house or with the director to have their performances recorded, were finally afforded the opportunity to copyright their own performances. Now they have the exclusive right to, they can either make a sound or visual recording of their performance. They can either reproduce a sound or visual recording of the performance. They can broadcast it, and they can communicate it to the public otherwise than by broadcast, without any prior permission required. And this was an important development. Now, what about the ownership of copyrights? Where does the ownership vest for different copyrights? Now, it's straightforward enough to understand that if you're an author that's writing a book, the copyright will vest in you. If you're a painter, if you're an artist that's painting or, say, designing a graphic illustration, the copyright will vest in you. But it's not always that straightforward. As some of the examples came about yesterday, there was a question that asked, what if a lesson plan that was designed, and I think it was Perryman that asked, who would it belong to if you were employed by a school? We'll come to that. But who owns the work if you work for a government? Or as a PhD student doing research alongside a doctoral supervisor? Who owns the work done then? As mentioned earlier, in both film and sound recordings, the ownership is vested in the producer of the film, the one who finances it, not the director, not the screenwriter, the one that puts in the money. He is vested in the authorship and ownership of the film, and as it goes, the sound recording. This might make sense to you in the sound recording case, as I'm sure we're all aware of how predatory the music industry can be. And music labels have used their influence over artists to retain ownership of their work, sort of cutting them out of the process while going on to make millions and millions of dollars, rupees, whatever the currency, off the back of creative artists, which have now got artists who fund their own work. They'll produce it themselves. They'll put their own money back into their art and reclaim ownership. That's something that's really interesting to see. It's a really interesting development to see. As I mentioned before, in the music context, the copyright over here, the music is vested in the composer, whether or not he reduces the music to a graphical notation. Now, what about newspaper articles? Is it the journalist's copyright when he writes on a news piece on current events? Or is it the copyright of the news agency that sends him the material, which is a majority of the chunk of the news? It's sent in fixed bytes to different news agencies, to different news companies, whether they're journalists or whether they're newspapers or broadcasting. Where does the copyright subsist in material that's happening to everyone? Any ideas? Hold on, let me check the chat. All right. All right, so Simran asked the question, what happens in the case of schools recreating certain plays, movies for their annual day? As I mentioned yesterday, and we'll come to it, there's certain acts that are not considered infringement when they're done by certain people for certain purposes. And one of these examples is for the purposes of education. The law allows certain leeways when copyrights are used for the purposes of educational enlightenment or in the running of an educational institution. It will overlook a couple of infringements here and there in the larger public interest. How does IPR work in the case of social media content posted as posts and captions on our own page? That is exactly what the latter half of this session is about, but very quickly, it is your own. If it is your original work, if it is your own 100% from scratch, if you've created that, it belongs to you. But as we see, it's very twisted because at the start of, when we join Facebook, when you join Snapchat, when you join Instagram, you're thrown up a little agreement, a license agreement that I agree, deny. So we'll go on to see how that influences who really owns the content over then. But now, what about journalists? Let's get back to it, and please keep the questions coming. This is really good. What about journalists? Who would you say a journalist should have the copyright reside in himself, or is it the news agency? What about, say, a journalist who does a feature on the life of a celebrity? That's in the course of an interview. Celebrity is narrating his life, blah, blah, blah. It's where I grew up. And the journalist goes, he takes all that content and he writes a story on it. Can the celebrity then stand up and say that, no, guys, it's my life. Copyright belongs to me. It was based on my narration. If you think that, would it work that way? Say, guys, the chat. All right. Good, Sasha. Yes. The celebrity would not be able to stand up and say that, this work is based on my narration. Or the news agency that forwards the journalist a big chunk of news cannot say that this copyright in this content belongs to me. Copyright at the end of the day will belong to the journalist who absolutely right, Sasha. That's absolutely right. It belongs to the journalist because, as I mentioned earlier, it takes the law will look at skill, the law will look at labor. And at the end of the day, it's the journalist that's sitting down and compiling all of these things and putting it out for the world. So well done. Yes, spot on. Now, onto the important stuff. Infringement. Now, the Act provides that when work is made by an author in the course of their employment, all right, guys, we're going to backtrack here because I'm not done yet. I jumped the gun. Apologies for that. Yeah, so we're still talking about ownership. Pardon me. Now, the Act provides that when a work is made by an author in the course of their employment, say by a newspaper or magazine or periodical, for the explicit purpose of publication in said format, in the absence of any formal contract to the contrary, the proprietor, which is the newspaper, magazine, or periodical of the service, will be the first owner of the copyright. So that's a little twist to the journalist's example. As I said, it will he's he's able to fine-tune his contract with the newspaper. If he does, if this journalist that writes all these news stories a day stands up to his newspaper or his employer magazine and says that this is my work and I want the copyright to continue to subsist in me. And if the newspaper is willing to let it be, or say or he's a freelance journalist, then the copyright will subsist in the journalist. But if there is no agreement that specifically mentions that the journalist will retain his rights, the law assumes and presumes that right of first ownership will reside in the newspaper, magazine, or periodical, because that's what they're paying the journalist to do. They're paying the journalist to write for them, to publish. Now, this sort of gives them the right to reproduce and circulate your content on a daily basis. This applies to an author's employment in the course of a contract of service for any organization, not being that of a newspaper, magazine, or periodical as well. Say you're employed by a company to draft a research proposal or to do an audit and draft a report. Because they're paying you to specifically draft that report, they will own the first right of ownership on that copyright. Now, what about a photograph or a portrait? That's that a photographer is requested to take, or the painter is requested to paint, or an engraving or a film made in exchange for valuable consideration, like a payment or whatever floats their boat. Such person that gives the valuable consideration will be the first owner of the copyright therein. But once again, you're going to hear this phrase a lot over the next 5 minutes. This is in the absence of any agreement to the contrary, meaning that, remember, guys, that we are always able to negotiate the terms of our work. It's in the real world, it's a little difficult when you're negotiating with a multinational company or national newspaper. Contracts tend to be very fixed that way and skewed in the favor of these big parties and against little journalists and creators like us. But if there is an agreement, if you are able to sort of weasel your way into including terms in the contract that benefit you, you definitely should, because all these contracts will inevitably favor the person doing the employing. So now Sasha asks, what about freelance journalists or freelancers and other professionals? Still live with the news agency. As I said, it all comes down to the contract. If they're able to negotiate a favorable contract that benefits them, that allows them to retain ownership of their rights, and only allows the person that they're submitting, the organization that they're submitting the work to as a license and not as an ownership. If they're able to specifically mention that in the agreement, in the contract that they sign with the company before they start working for them, then yes, we can say that the creator, whether it's the photographer, whether it's a freelance journalist, will retain the rights of ownership. But in the absence of a contract that specifically mentions this, it is unfortunately the news agency, it's the newspaper, it's the magazine, it's the broadcasting agency. The law presumes them to be the first owners of the copyright of your content. Now, what about government work? When you're working for the government inevitably is the first owner of the copyright. Then, in the absence of an agreement to the contrary. Now, what about as in taking a picture of the photographer in the photo studio or the portrait painter? Work that is created at the behest of another in exchange for valuable consideration will belong to the person making such valuable consideration. The person paying you the money will own your content if it's specifically what they're paying you money to do. What about apprenticeships or internships? It's something that's really important for you guys that one of you all asked yesterday. Again, in the absence of an agreement to the contrary, the work will vest with the organization. Which is why seminars like this are important, because we should be able to know our rights. You and I are wholly able to stand up to these organizations and say that I would like to work for you, but I would like to do it on these terms. Is this okay with you? And just see what they have to say. And if it's amenable to you, if you can deal with it, then carry on with it. But if not, then know that in the course of your apprenticeship or internship, whatever you create will belong to the organization. Now, what is an apprentice when we think of an apprentice? An apprentice is a student that's bound to another master or a person skilled in a particular trade for the purpose of learning his trade or calling. Now, the contract here is of such a nature that the master teaches, the student learns, and serves the master with the intention of learning. In this context, very obviously, the work will belong to the teacher. And this is true in most specialized occupations that require long periods of training, like, say, a sartorialist who goes to Italy to study under an Italian master tailor, or someone who really wants to make sushi and will only really learn the art working for free under a sushi master for 2 to 3 years. All the work created in that point will belong to the master, to the teacher. Now, what about an employee teacher like Miss Akshara or Miss Perry? What if they were to write a book, a textbook on the subject that they're teaching in the course of their employment with the college? What then? Well, in this case, they would be the first owners of the book that they write. Because let's look at the terms that they were employed on. They were employed to teach, not necessarily to write textbooks. They're doing that of their own volition. They're applying their own skill, their own labor, and their own judgment. But again, all of this, remember guys, is subject to the specific agreement that they've entered into with the college. See, at the time of Ms. Akshara's joining Xavier's, her contract stipulated that anything created in the course of your employment here will belong to St. Xavier's College. In that case, tough out of luck. But if the contract does not mention it, if there is no specific mentioning that anything that they do, anything that they create is the property of the college, if they do decide to write a textbook, it will belong to them. Since they, again, as I mentioned, since they've been employed to teach and not specifically to write books. Now, what about collective works? You guys are going to be acquainted with collective work soon, like a group research project or, like a newsletter that the final years, that the journalism students usually make in their last semesters, or magazines or encyclopedias where work by many, many, many different people is collated together and put out as one chunk. Over here, the first owner of the copyright is the one who collects, who edits, and organizes the work. To say that one EY journalism student who's going to sit down and wrangle all his or her, mainly her, wrangle all her classmates to file in their reports on time, hand in their designs on time, and sits and gets on in design and puts all this together. First ownership will reside in her, because she's the one who's expended so much amount of energy in collating all of this and putting it together. Regardless of the fact that it was written by that person X might have an article in it, person Y might have drawn an illustration for it. The law assumes that in a collective work, when many people are coming together, it's the one who sits and puts everything together. What if it says that the work they do is owned by the uni, but it's a novel on a completely unrelated topic? Then that works. That works. But again, it depends, because sometimes universities can be very sneaky. They can say that whatever you create, they can't really do that, because they can only claim stuff, like you very aptly noticed, in the subject matter that they teach. So like a fiction novel from MAM would be completely acceptable. But maybe, I mean, MAM also teaches, has taught in the past and might teach in the future communication skills and creative writing as well. So it's a little iffy there. But yes, if it's novel completely unrelated to their field, or a literary work that's completely unrelated to their field, then I feel like it should escape, contractual terms. What about musical works? Yeah, you're right. If it's a science teacher writing fiction, yeah, that's a good example. Then it should be all right in the course of. I don't think there would be any contractual infringements there. What about musical works? For the musicians in the audience, remember that the first owner of the musical work is the composer of the work, even if it has been commissioned by, say, a film producer or any third party for their use. It's very important. If you're a musician, always remember that if you are the composer of your original music, the first right of ownership, once claimed by you, will reside in you. Yes, ma'am. Even in terms of musical remix, the one making the remix will get a copyright, but it will not take away the copyright of the old one. It's simply a whole new thing. It's viewed as something that's been bettered or changed in an original way. That there has been some skill, that there has been some labor, that there has been some judgment, some professional judgment enacted on that original music, make it into something completely new. So the completely new thing will have its copyright vested in the person that makes the changes.
And what happens to these songs, which, like, I mean, you have these, some of these religious songs which just pick up the Bollywood tune and they have the other words. Uh,
Yeah,
and it just becomes so popular. And, I mean, there are places like Shirdi and all wherein these songs are played. Phenomenal.
yeah.
So, what happens to them? Because the tune is original, right?
Yes, the tune is original, ma'am. But if there is, say, if this religious congregation takes the original Bollywood tune, a very popular tune, and sort of makes minor changes to it, e- minor changes in the sense that they add some harmonies to it. There's more people singing on it. They change the rhythm up a little bit, or they change the tempo a little bit. It's the law recognizes it as a whole new piece of art. It recognizes it as a whole new song. But now, as Chavi asks, what about covers of songs where you have a popular, say, Ed Sheeran singing a song and then someone else making a cover of it that goes viral on, say, YouTube or TikTok or whatever? Covers are a little hard to say because we're gonna do that in the next slide in infringement, that you have levels of copying. You have levels of, as I said, inspiration, and then you have direct copying. If you're going to sing that song word to word, note for note, chord change to chord change, you're going to keep everything the same. And if the only thing that changes is your voice, I'm sorry, you do not have a new copyright because you're still basing your work wholly or substantially on the original. Now with religious tunes like the example that Akshaman gave, it's a little difficult because you can't really have a copyright on a prayer. It's something that's been going on for time immemorial. And more often than not, the original authors are lost for the most part over time, unless they're remembered. But, prayers come into public domain, so they cannot be copyrighted per se. But if applied to Bollywood tunes, that is sort of, the law will say that, "Ooh, you did something different there. That's something that maybe people might not have thought about before. So there, I'll give you a copyright. But don't covers covers do not count. If it's a literal, note for note remake, it's not a remix, it's a remake, you're copying it, then a copyright will not subsist. Yes, even political parties use them quite shamelessly, I might add. But yeah, coming back to musicians, if you are a music composer, if you are a composer of your original music, always remember that regardless of who you compose it for, whether it's for an advertising agency to use in a jingle, whether it's for a short film to use as their background score, you will only assign it, you will only license the use, meaning that for a particular period of time, you get to dictate for how long and for what purpose it is used for exactly. But always remember that the original copyright will subsist in you, the musical composer. The producer in this case only gets the license, like I said, to use the work for a specific purpose that is decided by the both of y'all, agreed by the both of y'all, and but the composer still retains overall ownership and the other rights that come with copyright. So you can still sell it, he can circulate it, he can perform it to the world without fear of this other party coming in. Now, what about artistic? Now, the artist who creates the work is the first owner of the copyright. So, but as I mentioned before, where the work is created in the course of employment, where the employer specifically employs the artist to create a work for a specific purpose, say like the painter that's hired to paint a family portrait. The painter cannot say that, it's my work, it's in me, I own the copyright. No, the family that's hired you, that's paid you a large sum of money for that very purpose that you paint this picture for them, will retain the rights of first ownership. All this is easy to say now. Like, say, if you're an employer of a newspaper, a magazine, or a periodical, they have only a limited right to use the work. And that's only for publication. They can only publish it, they can share it, circulate it, but they cannot make copies of it and sell it in that sense to another magazine or another periodical, which is how you see certain celebrity pictures appearing in more than one magazine. If that one photographer gets that one shot at that right angle, he can sell it to a handful of agencies around the world that are covering the same story. He still retains ownership. He sells the picture on a license basis. But remember, guys, I'll keep stressing this. All of this is determined in the specific contract that you get into. I can do a whole other series, a whole lecture series on contracts because they're so important, they're so broad, they're so vast. But in this case, as a creator, please know that whenever you're hired for work, take the time out to draft a contract. Even if it's a simple one-page thing, there's tons of formats out online where you know what to cover, the important bits. What are you making? What are you making it for? Are you charging for it? Who retains ownership? Now you know what questions to ask. So just bear that in mind, and as we move forward, it'll drill in a little bit. Uh, so now let's talk about the terms of ownership, meaning for how long did they last? Okay, one question before that. If you sell the painting, does the painter have any ownership? No. If you sell the painting, then the copyright moves with the painting. Because you're selling the painting. It's leaving your possession, it's leaving your ownership. Think of it as a property, right? Like I said yesterday, intellectual property is just like property. It's just in a different form, in a different abstract shape. It's an abstract concept, but at the end of the day, you still view it as property. It's something that can be bought, sold, transferred, assigned, licensed. It can be leased out for a specific period of time. So if it is sold, you're transferring your rights of ownership. You're transferring your rights of copyright, and along with that goes the copyright of the painting.
Sean, what happens to films which are adapted from books, novels?
Uh, then, ma'am, it depends on how far the creators of the film have done their due diligence in approaching the original author, taking permission for a literary adaptation. Because if
But they
it's
do have to take permission, right? They
they
can.
do have to take, yes, they do have to take, which is what the whole Chapak thing that I started with in this movie
Yeah,
today,
yeah.
this lecture today, was that Rajiv Bharti, the author of this script, felt that Deepika took a story that was loosely based around his and made a movie out of it without cutting him in on the deal. And this happens a lot. This happens a lot where big movie houses sort of brush over small authors, small time authors, but not that don't have as much pull as like a Tom Clancy or a Jeffrey Archer or a Stephen King, and sort of steamroller them out of existence while going ahead with a major motion picture. But the right thing to do, the morally and legally right thing to do, is that they will have to approach the author, who is the owner of the copyright. The author of the original literary work owns the copyright, and it's only him that can decide whether he wants it to be adapted and in what way he wants it to be adapted for, say, even for theater or for a street play, and this applies to cinema as well. So, just a few questions before we break for 5 minutes, if that's all right. If you create a piece of work under contract for an employer, but they don't use it, can we then use it for personal and commercial use otherwise? Amatullah, that depends again on the terms of your contract. If the contract says that anything you create will be owned by them, it frankly you cannot say what they can and what they can't do with it. You cannot use it. If the contract between you and the organization states that they own whatever you make, then they own whatever you make, and you cannot use it for personal, commercial use or otherwise. The contract will usually specify that. Then anything you make will belong to the company. You will not have any rights to it. And when you leave the company, all everything that you've created, all the rights to everything that you've created will pass on to the company and will become property of the company. So, no, you cannot use it for personal commercial gain otherwise, subject to the terms of the agreement or the contract that you sign with them. Now, Christo asks if making a contract, something a specific document is required, or mentioning it in mere email can work. So contracts can be handwritten on a piece of paper, on a piece of tissue, as long as it, shows the willingness of both sides, signed, mentions the brief terms, anything works. WhatsApp even works at this point. It's recognized by a code of law is what I'm trying to tell you. Simon asks, so if I buy a painting and then start painting the exact copy of it and sell it, no, you are legally, that's interesting. That's interesting. But are you buying the original copy of a painting? If so, then yes, I think you can make a copy of it, and sell it saying that you own the original. I think then yes, you should be able to. You should be able to. Kushi asks, can a signature at the end of my painting act as a copyright? I mm, I think that's very interesting that you say that, because this sort of harkens to one of the first ways of asserting ownership on a finished piece of art, is to just sign your signature on it and makes it truly yours. Um, yes, it will act as a copyright, but considering you live in 2021 and you have an entire intellectual property right regime that's backed by law in the country that you live in, you will be expected to go the extra mile and register it. Just if it's worth something, register it. But yes, just to answer your question, yes, it sort of acts as a copyright to define ownership. Rugveda asks, in some music videos, they show certain books. So the music artist is reading a book. Murakami. Nice. Book shown as a prop in the story. Does that also come in? Yes, set design is very difficult, and it's a whole profession in and of itself when you're building a set. Make sure you don't include anything, that might be taken affront to, that might be taken offense to in the background. That includes other people's copyrighted works, could be famous paintings. So it really depends. But yes, it can be copyrighted because think about it, right? Like you say you're a painter, you're say, what all the painters I know are dead, but say you're a famous painter, all right, and you're pretty reclusive from the media, and you cater only to the upscale elitist tastes, and suddenly you see a painting that you usually only sell to high profile clients appearing in the back of a TV show. You're gonna ask some questions. But it depends. Do they own the original? Like Simran asked, do they own the original copy of your painting? Then it gets a little iffy. But think about it, on the movies, on set designs, they have a specific budget that they can't go around buying expensive artworks for. So they have to be very, very, very careful with what they put on screen, what they show on screen. If you get permission from an artist to use an artwork as a reference for Instagram, uh, no, because you've gotten permission. You make sure you take a screenshot of that because that acts as your contract. That shows that there's been deliberation. There's been a meeting of the minds. If they agree to it and you agree to it and you go ahead and do it, they cannot then turn around and cry foul because they've already given you permission. You must have evidence of it. You must document it. Brigade asks, follow up, what if they want to recreate a moment from a classical movie? Movie makers no longer exist. So we're just discussing the terms of copyright. We're literally at the bottom of the last point is, so that what that means is how long does the ownership last? It doesn't last in perpetuity. It's impossible. Whether it's a patent, whether it's a trademark, and as well as copyrights, the law sets certain time limits. After this time limit, it gets pushed into the public domain, which means that it's now a creative common. Anyone can use it. So to answer your question, if you're going to recreate, say, a Buster Keaton, uh, uh, comedy sequence, or a Charlie Chaplin sort of action comedy sequence that was made just about 100 years ago, then sure, go for it, because copyrights only last for 60 years after the death of the author, as I'm going to mention. So I hope that answers your question. Ma'am, what say we take a 5-minute break now after this last question? What about using product images, logos from a brand, company website, and social media creative? Big no-no. Big no-no. That is infringement, my friend. What about using product images, logos from a brand, company's website, and social media creatives? Big no-no unless you have permission, unless they specifically allowed you to do so. Otherwise, it's infringement. It's against the law. So, ma'am, 5 minutes, and then we come
Yes,
back.
yes, Sean. Let's take a 5-minute break and then we can join back.
All right.
So I've been getting messages, guys, saying that a couple of students have been logged out. I have unlocked the meeting. So if anybody has logged out, Noila, um, and a couple of first year students, they can just join back. Okay, okay. Noila says she's in. Anyone else, please let me know.
Hello. All right. So before we start, Simran had she had a follow-up question. Makes an ad, the company on a portfolio, doesn't post it on social media or anything. So that's the problem. Well, Simran, it depends. If you made it for the company and if they paid you for it, wait, you made an ad for a company for your portfolio. I'm a little confused. Did they ask you to make it? It's just something that you made yourself?
Just something that you made yourself, like you got an idea, okay, like maybe for
Mm-hmm.
Apple, this is possibly an ad that could work. So I made it
Uh-huh.
and just I show it to people as like this is like my portfolio work. Like I'm
Oh,
not
that as long as you don't use it for commercial gain, you're not and yeah, as you mentioned, you don't post it on social media, you're not circulating it. It's purely for your portfolio, something to display your creative talents. Absolutely, there's nothing wrong with that. But the moment you start, passing it off as something or circulating it around for commercial gain or personal profit, that's when the law will sort of take a stance against it. So it's
Excuse me,
okay.
sir. I just had a very quick question.
Hit me, yeah.
So, sir, I wanted to ask, what if, suppose, a production designer
Mhm.
kind of imitates a building that already exists on a production set, but does make a couple of cosmetic changes? So then, will
Mhm.
it be the design will be uh
Mhm.
like
I understand.
can the yeah.
So this would depend wholly on the building in question. So now we're talking about something that was designed by a renowned architect. That's uh, yeah. If it was designed by a renowned architect, and the architect is going to have a copyright on the design of the on the design of the building and against its recreation for any purpose, I believe. So that there might be a bit of a problem. But if it's of a historical monument, like say like the Gateway of India, if he remakes the Gateway of India for a production set, he wouldn't need to bother with the cosmetic changes. He can go for it as is, because by now it's something that's it's become a part of one can say common property. But
Okay.
if it is say a brand new building that and the architect is a renowned one, a renowned firm that's still alive, up until a period of 60 years from the date of building the building, the copyright will subsist with the architect. So it will take permission at the very least, permission to recreate.
Okay. Okay. Thank you.
You're welcome. Good question, guys. You guys are really thinking about this and applying your experiences to it. So I really appreciate that. Keep them coming. Let's get back to it if everyone's ready. I had to run for a quick uh, wardrobe change. Who knew teaching could be so exhausting? It's working up a bit of a sweat here. Ma'am, are you there?
Yeah, sure.
Let's go. Let's continue.
Start, yeah.
All right. So yeah, we were discussing terms of the copyrights. And ma'am, I'm really sorry. Yesterday I gave you a wrong figure when you asked me about if an author dies and who will the copyright pass on to. Uh, Sort of like a blanket number, all copyrights are valid for a period of 60 years. They just vary 60 years. They just vary from when that 60-year period starts, depending on whether it's a literary work or a musical work or an architect or a building. But yeah, like I said, the starting point varies from one artistic expression to the other, and depending on the circumstances surrounding its publishing. So, say for literary, musical, and artistic works, okay, that you have a single or group of authors, the copyright remains through the lifetime of the author, plus 60 years from the year after his death. So we were talking about Andy Lane. Say if Andy Lane were to die this year, but bless his soul, hopefully it doesn't happen. But if he died this year, then the 60-year period would start from next year, 2022, and run for 60 years after that, which means that from 2022 to 2082, the copyright would still remain in Andy Lane's name, in Andrew Lane's name. This works for your music composers, this works for your painters. For literary music and artistic works, I'll repeat, the copyright remains through your lifetime, plus 60 years, starting on the calendar year after the year of your death. But now, what if this literary work or this musical work or this artistic work was published anonymously or pseudonymously, and you don't know the author? Well, then it'll run for 60 years from the year after the year of publication. So if Andy Lane, God rest his soul, had died 5 years ago and his work were to be published this year, 2021, the 60-year copyright period would start from next year and likewise run until 2082. Now, in the case of posthumous publishing of work, it'll run like previously for 60 years from the next year of publishing. And the same applies to photographs, films, and to sound recordings. All copyrights will run for 60 years from the year after the initial year of publishing. So I hope that's clear. Now we move on to the important bit, different kinds of infringement. Now, what is infringement? This is a little something that's hard to to define, and even the act sort of struggles with defining infringement because it can happen in so many different ways, so many different extents, with different intentions, and all of that. So I'm just going to briefly touch upon a few different forms of infringement that we might commit in our day-to-day exploits, and that we are left open to when we put our creative endeavors out into the public. Now, like I said, the Act is not very specific about what exactly constitutes infringement, because it's hard to quantify something that can at the same time be subtle and distinct, be overt and overt at the same time. But broadly, the law recognizes it as the use without a properly acquired permission or a license from either the owner or the Copyright Office, or when a certain protected work is copied, sold, distributed, exhibited in public, or moved illegally across the nation's borders. Like I said, think of copyright as a right in property. Think of your creative work as your possession. And remember that the copyright is a negative right, that what you can do with it, no one else is supposed to. So if by chance someone does do so, even one of those things, like only you can distribute it, only you can sell it, only you can make copies of it and assign it and lease it. So if someone goes ahead and does that behind your back, without your permission and without the permission of the Copyright Office, if your work is registered, then that counts as an infringement. Now, to what extent do they do that? How, what their intention was when they were doing that, that all remains to be seen on a case-by-case basis. And it's very hard to quantify in law what exactly that be. Now, say a straightforward example of a blatant infringement would be, say, a printer takes a copy of the latest published book by, say, Arvind Datta and released by another publishing house and makes copies of the same for circulation and makes a quick buck. So this is unlicensed publication. He's reproducing something that's the creative property of something else that's already been leased to a publishing house. And if a third-party printer goes in, takes that book, sells, makes copies, all of that counts as very direct infringement. And it's very, very legal. Say, for example, there's a specific book that's published only in one country. Or say there's a specific book that's published only in France and not anywhere else in the world. And an Indian visitor traveling there brings back home a copy of this book, makes further copies, and floods the market with it. Again, infringement. Or what if a student from one of the three batches lifts the whole research paper that he or she finds online, puts their name on it, changes a line or two here, and submits it as their own? Infringement against the law. But it's not always that straightforward. Okay, there's two major factors that bear consideration. Whether the copying has a causal connection. Is there something that causes the copying to happen? Was it deliberately made? If it was deliberately made, like the like the one printer in the first publication, then it is direct copied. It is directly copied. But if it was unintentional, then it counts as indirect copy. Now, this causal connection is inquired into to determine the motive. Was there a monetary benefit? In the case of the printer, yes, there was. In the case of the student lifting the research paper, his motive was to get a passing grade and to be free of the labor, skill, and capital or judgment that he would have to put into making an original work of their own. So the causal connection is the first thing that's looked at. Now, say a poem, for example, is copied verbatim by one person and published in his own name. Meanwhile, the same poem is paraphrased slightly and published by a third person. Now, the second thing, the first thing is direct copy, where you're taking, you're taking the poem word for word and you're publishing it as your own. That's a case of direct copy. But if you take the poem and you change a few lines here and there, it's indirect. But in both cases, they are still infringement, just at different degrees. Now, in determining whether infringement has actually taken place, the extent of the alteration of the original work will be looked at. How far were changes made? Did the author just settle with, a few lines here, a few paragraphs there? Or did he exert sufficient skill, sufficient original thought, sufficient labor to make it substantially different, like Andy Lane did with his Young Sherlock series? He created a whole new world for same character, regardless of the fact that it was the same character. So there was no infringement there. So before I move on, there's another question, but another two questions. It's not for individuals, but you can add agency and a client, between an ad agency and a client, who would own the copyright of creative materials? Generally the client, because like I said, they're paying the agency huge sums of money to create content for the purpose of furthering the agency or furthering the client's business or their motives. So most definitely the copyright would subsist with the agency that's hiring, with the client that's hiring the agency to make the creative materials. So after the 60-year time period, does it become open source? Yes, it becomes open source. Or can someone else copyright it? No. After the 60-year time period, it becomes open source. So this concept of renewal after the time ends only applies to trademarks. When you're a business, like this client that's come to the agency to work on their brand image or their logo or a catchphrase that's then trademarked at the trademark office, that's only valid for a period of 10 years. At the end of the 10 years, this corporate, this MNC will have to go back to the trademark office and say that and prove that I'm still using this copyright. It is in my interest, it is in my business interest to renew it, and I need it renewed. So this 10-year period sort of keeps corporates on their toes and allows, unused and unclaimed trademarks, logos, brand names to sort of fall down to be re-trademarked and reapplied to and used for different purposes. Now, coming back to infringement. Okay, now the general principle of what constitutes infringement has evolved over time. Is there no infringement if a person has spent sufficient labor on what he has borrowed from another person to make it a new original piece? Yes. But the ultimate question remains as to whether there has been a reproduction of the original work in substantial form. Now, what is substantial in this case? Like I said, it's hard to truly determine and will depend on a case-by-case basis. But asking and answering these questions sort of boils down to the following types of infringement. You have substantial copying, you have indirect copying, and you have conscious, unconscious, and subconscious copying. So we've already discussed substantial and indirect, but just to run over them again, substantial is when the original work, when the lifting from the original work is so blatant that it cannot be ignored. It's impossible to view one without being reminded of or it alluding to the former, to the original. So here, the volume of the copied material, along with the intention behind the copying, whether to save time and labor, and the extent to which the original and uncopied work clash and compete with each other would bear consideration. Indirect work, indirect copying a work may be copied by making a copy from a pre-existing copy. This is too much. This is often seen in institutions without plagiarism checks, where work is taken from one unnamed source without knowing where that unnamed source got that work from, and then it's just really messy. So what's really interesting is are the concepts of conscious, unconscious, and subconscious copying. So conscious, like the direct copying, is when the person is fully aware that they are copying someone else's work. Unconscious is when, in the case when the flow of idea and expression is so genuine from the mind of the author, it's so spontaneous that they have no real clue or they have no real knowledge that such a work might already exist, and it is wholly possible. It's often the case when the same conclusion or the same outcome, or more or less broadly the same themes, are arrived at by two different individuals, but a definite causal connection. It has to be proved that there was motive for one to copy from the other. That will have to be proved in the case of unconscious copy. Subconscious, this is when the author, the creator, has interacted with or sort of been exposed to an original work, and without truly realizing it, without truly intending to or meaning to, uh, there's no conscious aim, but invariably it becomes a recreation of the original art. And this happens to all of us. We're exposed to certain designs that we might scroll across on, especially artists, maybe on Pinterest or on Instagram, and then you end up invariably, revisiting certain themes. So then it depends on what extent are you going to be lifting from that original work, and what spin are you going to make it yours. Now, the truth of the matter is that courts are forced to interpret these matters on case-by-case basis. And as I mentioned again, it's impossible for any blanket claim to be made, as every act of infringement is motivated by different means, carried out in different ways, and results in varying consequences. Now, it will be seen that courts, in light of the Bollywood examples that we discussed yesterday, will take a liberal interpretation of what constitutes infringement or otherwise. And they do this to sort of facilitate the production of such work. And it might ensure it's to the detrimental of the original creators, most definitely. But if they were not to take such a liberal standpoint, it would be to deny the fact that ideas influence each other, that everyone's influenced by another's ideas. And if they were to take a hardline stance, it would bring the creative industry to a halt. Just yesterday, I saw something that really surprised me, that Satyajit Ray, the renowned Indian film director, was apparently one of the first to come up with storyline of an alien visiting Earth. And if you look at his sketches, you'll see that they predate Spielberg's E.T. And you know, he just wasn't able to get the movie off the ground, but Spielberg was. Now, can we say who copied whom and who was influenced by whom? Satyajit Ray didn't mind. But that just goes to show that, people get influenced when it's the one who brings out final expression is the one who usually enjoys the copyright. Now, it's just to mention it, but there are civil and criminal remedies available for the infringement of copyrights. Civil remedies, like yesterday's Bollywood example, you can bring an injunction where you can force someone to stop using your work, stop reproducing it. Or the criminal punishment is, if found to be valid, and since infringement is a criminal offense under the Copyright Act, the punishment for this stands at imprisonment from anywhere between 3 months to 2 years and a fine of 50,000 rupees to 2 lakh. So depending on the modicum of the crime. Someone asked before, like when would things not be considered infringement? Wouldn't be considered infringement when it's fair dealing. We'll discuss fair dealing in a second. Things like reporting judicial matters, or reporting current affairs by newspapers. It wouldn't be infringement when you're talking about these things. Education purposes in certain circumstances, or say public library is making a set of copies for their own record. For a public library, no one, if you can't really hold them to account. Or if it's a reproduction of a work to be kept archived in a museum or an institute for research, or truly any official government notification or law that's passed by legislature. No infringement, it can be copied, can be used within boundaries and only for pure means, pure intention. Now let's quickly branch over what copyright looks like on social media. Now, as I mentioned, when we all join these social media platforms, regardless of what they are, how many of us have truly actually read the licensing agreements before joining an online platform? I can presume the answers because barely anyone does. I can say I have for first few pages at least, and it's very worrying. But it always helps to know what the term means and what they are doing with our data, with our content. If someone asks, what is the nature of copyrights when you put something on Instagram? So before I jump into it, just broadly, all these platforms, Facebook, Instagram, Behance, Pinterest, they are hosting platforms. They're taking something from you and they're getting something and they're giving something back. They're giving you a platform to host your content. And when you hit that, I agree, and it depends on platform to platform. At least for Instagram, I'm most certainly aware that everything that you upload on there, be it your stories, be it a reel, be it your posts of pictures or videos, you automatically hand Instagram, which is now Facebook, a license to use it, distribute it, however they see fit. It seems inflammatory, but it truly is the case. If you, I've prepared a toolkit for you guys to go through and sort of familiarize yourself with the different aspects of copyrights on social media and otherwise. But I've included their terms of use, the user licensing agreements. And it's called a licensing agreement because you agree to give them your information to broadcast. And in return for them hosting your information, they're sort of sneakily getting a license to use it anywhere they want, however they want. And we're all sort of in on the joke. Like, so let's start with Facebook. So Facebook has a copyright strike system. I'm sure we've all reported posts on Facebook before, on Instagram even. So it's a sort of reporting system that works in the same way. It's also sort of similar to YouTube, except that they aren't forthright about it. If you're a creator on YouTube and you do infringe on the copyright, they will let you know that you're infringing on their copyright. But Facebook is a little subtle about it. They have like a 3-strike system or a multiple strike system. Essentially, a copyright violation on your part or a trademark violation, like using corporate logos and imagery for your own benefit on the platform, if found actionable by their software, by their algorithms, and true against you, gets you a penalty on your account. Now, how tough that penalty is, how long it lasts, and when it wears off is all variable. It would depend on the extent of your violation and the case that Facebook can make, that their system, that their automated little bots can make out against you. But it must be understood that all of this is done through automatic content filtering. So, and it can be both extremely sensitive or completely lackluster and do nothing. But it has been noticed that they are stricter when it comes to live streams and uploading video content. Like another one of our peers asked yesterday, like on YouTube, he brought up the example of YouTube, striking down monetary benefits for live streamers that just happen to have something playing in the background. So everything that runs through the live stream moves through a filter that checks for all these things. And these sort of systems are just coming into place over the last year, 2 years, 3 years. Now, if and when you're accused of violating copyrights or trademarks or any intellectual property on Facebook, the first thing that generally happens is that your content is removed. You are notified why the content was removed, and you are given a link to dispute the copyright claim if you believe that either your own rights to the content or your use of the content is fair. Now, a counterclaim will cause either this counterclaim by you refuting Facebook's accusations against you will either cause the original to be removed Or depending on the scale, like if you're like a business or if you're a large, post group admin running a huge group on Facebook, then this could potentially flare up into a large legal battle. So one must be careful with how much value they put on the content that they post. Under Facebook's terms of service and community standards, one can ideally only post content to Facebook that doesn't violate someone's intellectual property rights. But now the most straightforward way to do that is to make sure that whatever you post to Facebook, be it any other online platform, whatever you post onto these platforms is content that you've created yourself as far as possible. That's the number one way to avoid any copyright violation, period. Now let's consider that your intentions are pure and you just want a stick-tuned play in the background of your Minecraft playthrough. Even if you have bought or downloaded that song from iTunes or recorded the content on your own recording device or given credit to the copyright owner and included a disclaimer that you did not intend to infringe copyright. So you didn't even intend to profit from it. You just have 5 subscribers, but you modified the work and you added your own original material to it, and you think that the use is fair use, you might still be in violation of Facebook's copyright guidelines. So before one posts content to Facebook, they may want to ask themselves, did I create all this content myself? Do I have permission to use all the content included in my post? Does my use of this content fall within an exception to copyright infringement? Coming to that in a sec. Is the content protected by copyright? It's important to continuously ask oneself these questions before they frivolously post content online and open themselves up to infringement action. Now, Facebook makes clear what it stands on fair uses, and this definition of fair use is it's something that's also involved. It's also included in our Copyright Act, in our National Copyright Act. Now, fair use, it can be difficult to know whether a particular use of copyright is fair or not, but the law offers some factors that we can consider. So number one, the purpose and character of the use, including if whether such use is for a commercial purpose or for a non-profit, say, educational purpose, or a private purpose that is not commercial. Does the use transform? Does it change the original work by adding new material, context, and expression? So, for example, if you're using, famous models photograph to discuss the amount of photo editing on it, it is far more likely to be fair use than simply posting the model's picture online without any comment or without any text added to it. It recognizes parodies, may be fair use if they imitate the work in a way that criticizes or comments on the original work. Remember, criticism, commentary all fall under fair use, but if done with the right intention. Is the use, as I said, commercial or purely personal? Commercial or for-profit uses are more likely to be viewed as unfair use. And now, second point to be considered is the nature of the copyrighted work. The use of factual works like whole maps or databases is likely to be fair use if you're using it as opposed to highly creative works like poems or downloading an entire science fiction movie off Pirate Bay. Number three, the third point is the amount and substance of the portion that's used in relation to the copyright work as a whole. Again, what is the extent of your infringement? What is the extent of your borrowing from another source? Number four is the effect or the possible effect of this infringed use on the market or the value of the original copyrighted work. Will your use of this copyrighted content affect the original work in a way that the people might stop buying it, might stop viewing it? The video that we started our lecture yesterday, that was what I was trying to demonstrate to you. And I hope when you think back on it, when you think that it was a secondary account, not even an official secondary account, it was just a random account that had a whole music video, frame by frame, just without the words official in it. But though they had given credits, they had mentioned what the label was, who the artist was, they were still drawing away millions and millions of views away from the original artist's channel, or Vivo, the official publisher for YouTube for a lot of major artists. That still counts as unfair use. And viewing it, in a sense, just adds on to it. But what we did was for educational purposes, so that's all right. So to learn more about fair use, I've included a link to India's Copyright Office for fair use. So check that out if you all can. So remember that there's some exceptions to copyright. The application of exceptions and limitations vary from country to country. And since Facebook, a lot of the social media that we use is an online, is a United States based, are United States based organizations, we do share a common law system. So there might be some overlapping. So generally in countries that rely on exceptions and limitations, the use of copyrighted works should not unreasonably harm the original right holder's interests. It's always a good idea to get permission from the person who owns the original work before posting it on either Facebook or Instagram. You might be able to use someone else's content if you've gotten permission from them, like a question that was asked. If you have a modem of communication where you've asked for permission and they've agreed to it, they cannot then just turn back and rescind permission. They've already granted permission to you. But there will have to be a license, a sort of document, whether it's a chat, whether it's an email, that states that you have the owner's consent to use it. And you might be able to use somebody else's content if it's already in the public domain, as we'll see. I'll mention Creative Commons, which is covered by fair use. So there are certain exceptions to copyrights that we can keep in mind and sort of work around. Now, Facebook is doing something really interesting with this intellectual property conundrum, and they've developed what's called a rights manager tool to aid creators who put their work up on the platform. This tool is built into Facebook's larger creator studio and essentially looks to give people back control over their content and when and how it is shared across both Facebook and Instagram. There's more on that in the toolkit, so I suggest you'll take a look at it. I'm sure ma'am has sent it to you all already, and she will soon. Coming to Instagram. So because Instagram is owned by Facebook, a lot of their copyright policies are more or less the same. But here are some certain tips, just a few tips before you repost content on Instagram. Now, Instagram as a platform by default allows you to share links to others' posts on sites such as Facebook or Twitter and elsewhere. But an Instagram user who has access to a post can share it to their Instagram story or in a message if the content owner has allowed those actions in their privacy settings. So this is something that's small, that's among your friends. There's no native repost function in Instagram, but there are numerous apps available that allow you to repost others' Instagram images to your own account. While these apps make it easy to share someone else's post on your Instagram account, they don't make it legal. And it works vice versa. As creators, say as photographers or as artists looking to use Instagram as a digital portfolio, you're opening yourself up to people doing the very same thing to you. So here are several, if you would like to repost, I'll come to how you can safeguard your own work, but if you would like to repost another Instagrammer's photo of puppies to your account, get their permission first. You can leave a comment on their post asking for permission to share onto your own account, or as Simran asked, you can direct message them asking if you may either repost or work on that image. And the best way to do it is to take a screenshot of this message and sort of keep it safe for your own record, to cover your own back. Or you can use the contact information in their profile to email them for permission to repost content on their account, or use it however you wish. What about tips for posting your own content? Very broadly, in addition to being aware, first of all, I'm going to say this again, you have to be aware of your platform's terms of use license agreement. You should also keep in mind these following tips. Include a watermark. If you're a photographer, if you're an artist, if you're a creative professional of any kind looking to publish their work on an online space, include a watermark that's unique to your own, and that's difficult for people to erase. Yes, there are editing tools that sort of, nowadays when we talk about the online medium, there's always something that will refute any action taken to protect your copyright, but it's better to have some protection than no protection at all. So number one, include a watermark over your artwork. On Instagram, there's something really interesting called #binded, sort of Facebook's version of your rights manager tool that's incorporated into Instagram. That's sort of when you use that hashtag binded, you're indicating to Instagram that this is your own copyrighted work. So they will take a little extra precaution and extra measures to safeguard that from their own, so they say, I guess. Place a copyright symbol on your content. Remember, people, copyright subsists in your work simply by virtue of you having created it. You will not have to necessarily go and register it. A registration, taking your work to the registrar's office and paying the fees and getting it, mentioned on the registrar, is just a simple extra step that will help you should your matter ever go to court. It tips the presumption of favor that you really do own your copyright. If it, like I said, if it does come to court. But putting a copyright symbol is something that anyone can do on their original artwork, not copied artworks, on the original artwork. You can put a copyright symbol on your content to sort of let people know that you are aware of your rights, and it's sort of ask them to respect yours. Include a link to your email or contact details so that people can easily obtain permission from you. Make yourself, reachable. Make yourself reachable to people that might be interested in using your content legally, so they don't have to do so behind your back. Another rather disappointing tip is to post only low resolution images, but we're not here for that. I'll quickly run through Twitter. We've got 10 minutes left. So Twitter in the past has responded to copyright complaints submitted under a US Copyright Act, which is the Digital Millennium Copyright Act, DMCA. In one particular 2015 case, which was the first instance of Twitter actively taking down tweets based on a user's complaints about copyright infringement. This was a case of a comedian that had made a 140 character joke, and before she knew it, it had taken a life of its own and had been reposted and retweeted thousands and thousands of times. What she did was she filed a complaint under this act, the Digital Millennium Copyright Act. I've included a link to it in the toolkit as well. This comedian wrote to Twitter and she said that, I'm a comedian. My livelihood depends on the jokes I write for a living. I was just testing out a joke on Twitter and it is being used without my permission. So please take it down. So Twitter obliged her and took it down. And since then, it has been doing this over and over. Another example was with, if you're familiar with billionaire Mark Cuban, who owns an NBA team. I guess he has the money to sort of sway to it in any regard. It can be viewed that way. But he posted some angry tweets, having been fined 25,000 by the NBA. And when they were shared in a way that wasn't to his liking, he was able to get them taken down. So there is a section of this act, this DMC Act, that outlines the requirements formally reporting a copyright infringement, as well as providing, and it also provides instructions on how an affected party, that's you or me, can appeal a removal by submitting a compliance counter notice. So in the same case as Facebook, if you have posted your content on Twitter and it's unfairly taken down, there are means to appeal that and present your case. So Twitter states, as far as its most updated terms of policy is concerned, that the content is the sole responsibility of the person who originated the content. So they're putting everything on the user, but they reserve the right to remove content that violates the user agreement. So take that as you will. They will respond to reports of alleged copyright infringement, such as allegations concerning the unauthorized use of a copyrighted image as a profile or a header photo. But, and they also have a separate trademark policy for the use or misuse of brand names, entity names, and a separate policy dictating parody, newsfeed commentary, and fan accounts. So as with Facebook, Twitter under the American copyright law also allows for fair use, and it sort of covers all the points that we mentioned above, which is limited quotations for the purposes of criticism, commentary, news reporting, teaching, scholarship, research. That is not going to be taken as an infringement of one's copyright. But once again, it really does depend on a case-by-case basis. The law will consider the user's purpose and character, nature of copyrighted work, amount, extent of whether substantial or insubstantial amount that's been copied, and most importantly, the effect on the market as a whole, someone being harmed by it. So one way to work around copyrighted material is to register yourself with Creative Commons. So this one particular tool provides licenses for authors to declare their works, some rights reserved or all rights reserved, which is a way for creators to put their content out there on a safe platform that values um authors' rights and users' rights, and it's trying to bridge the gap between, both sides, both parties that are willing to do this legally, the content creators that want to showcase their artwork and encourage people to build off it and use it and interact with it, remake it in their own way, and it bridges the gap with people, with young hungry professionals like yourselves that may look for content to use that keeping in mind copyright requirements and that are looking to do so within the scope of the law. So, although Creative Commons is best known for its licenses, their work extends beyond just providing copyright licenses. They also offer other legal and technical tools that facilitate sharing and discovery of creative works. And they have a whole public domain dedicated for rights holders who wish to put their work into the public domain before the expiration of copyright. And they also have a public domain mark, so a tool that marks the work in the worldwide public domain as your own copyright. They were designed specifically to work with the internet, which is what makes their terms of use very user friendly and creator friendly as well. So briefly before we end, let me run you through certain steps that you can take to protect your own content on social media. The best way to protect your intellectual property from being appropriated on social media is to, unfortunately, not put it up there in the first place. Although you own the content you place on one of these social media sites, you have, as I mentioned, when you hit that I agree, you've granted a license to the media site to use the content in a way that they choose and for others to view it. Now, to protect your content, you can include a copyright statement on the file of the photos or in the, or, in the post, in the text space. And be aware that your property might get appropriated by someone that's not associated with the social media site. You must be vigilant to keep track of possible violations and be quick to file complaints. You have to be proactive. You have to be assertive. If you're not vigilant, you may not be able to support your claims in a lawsuit. So you cannot sleep on your rights. Now, once you know that you have certain avenues to staying on top of and retaining ownership of your work, law expects you to do the best you can. And unless you do so, it will not look at you favorably if after all that you approach the court for help. They will first look and ask, what have you done to safeguard your own work? Have you taken the necessary steps? Have you, done things the right way yourself before you go and claim relief for someone else violating your rights? So one of the best ways to file a complaint, as I said, is to do the Millennium Copyright Act takedown notice. That's usually very effective for US-based companies. And it allows you to send a notice in a specific format to the web host of the website that you think is violating your copyright. This ISP removes the offending copy and notifies the website owner. So all this is mentioned in the toolkit. I suggest again that you go after it. Overall, there are multiple habits that can and must be developed as creative professionals. Once you guys venture out into the marketplace, it becomes all the more imperative that one works on and develops these habits and practices to ensure that they don't find themselves or the individuals that hire them or the companies that hire them, that all of y'all don't find yourselves in hot water for having done something wrong. A few points, about 7 to 8 points. Number one, be aware of the law. Take the trouble to, if not study it, be aware of the broader basis. Be aware of the license agreements that you're interacting with, because they determine the course of your work. If you value your work, you will value where your work is being put. And if you respect your work, you will respect it enough to be aware of all these nitty-gritties. I'm sorry, Amatullah has a question. You can go.
I'll wait until you're done going through
All right,
the.
all right. So second point is, remember that ease of access does not equal free to use, as I mentioned yesterday. The key thing to know is that just because something is easily available online doesn't mean you have permission to use it freely. Images in Google search image are almost always copyrighted. Then just because you can find them doesn't mean you're legally allowed to use them. The images that I've picked up, I've been fortunate enough to have someone who's very strict with me to make sure that I at least try and cite a single word or just hint at where these images were sourced from. So remember that ease of access is not equal free to use. Number three, do not post, as I repeat, do not post the content that you know you did not wholly create. And if you did, if you do post something that you have only partly created, acknowledge it, be upfront about it. Do not pass it off as your own. An essential rule of copyright is if you didn't make it, don't use it and don't pretend to own it, regardless of whether it's an image, a clip of video, page, or a whole passage from a book, a newspaper article that's used for your research papers. Remember, if you didn't make it, ideally don't use it. Number four, don't manipulate content to avoid detection. Making slight changes to things like the audio in your live stream or some aspect of copy text in your research paper can indeed manipulate it enough to escape detection from social media algorithms or the department's plagiarism check. But it does not constitute fair use, nor does it absolve you of your copyright sins. In fact, making a slight edit to avoid a bot, if anything, shows a direct intention to steal intellectual property with awareness that you are doing it, which makes it all the more wrong. This goes for simple techniques like lightly skewing or cropping images, pitching audio up or down to slightly on your TikToks or Reels, adding a visual border or fuzz to a video. But it's all a very clear expression of awareness of copyright and, as I said, intention to steal. Consider it Exhibit A when you take into court over your intellectual property theft. Number five, ask for permission and be willing to spend a little. Like Creative Commons, there are a lot of web licensing platforms that deal in registered soundtracks, that deal in registered clips, registered artwork inspirations, music. So if it's a business page or as a major content hub or as an if you're working in an advertising or marketing agency, and if you really, really want to use the copyrighted content on your page or for your purpose, for your client, for whatever reason, take the high road, do it the right way. There are many licensing agreements that can be drawn up, and you can very easily ask for permission. It's as simple as dropping someone an Instagram message or a message on Facebook, simply asking them for permission to use it and doing so fairly. Are you an artist? As I said, find free sites online for inspiration and pay a registered archiving site like Shutterstock and enjoy premium content. Or, like I said, Creative Commons sources. More importantly, be proactive and assertive. Like I said, keep frequent tabs and regularly check up on the content that you've put online. If you find a violation across any platform, use the reporting feature and pursue the issue. Make sure that you reclaim what is rightfully yours. When in doubt, attribute. It doesn't always work. Like I said, including a simple disclaimer or that you didn't intend to infringe copyright can still land you in hot trouble if you are using the copyright for commercial purposes or in a way that opposes the fair use guidelines. But if anything, it demonstrates your intent to, at the very least, you're still doing wrong, but at the very least, it shows goodwill. And honestly, many small artists, musicians, and content creators like yourself and I do not have the time or the financial backing to pursue legal action like huge musicians and rock stars and movie directors do. So attribution is a very minor social element, and it cannot truly be counted to protect one from copyright infringement, but it's a token of respect and goodwill. Most importantly, remember that two wrongs do not make a right. We live in an age of easy access where we've grown up downloading stuff off the internet, pirating stuff from Pirate Bay, literally Pirate Bay. And it's easy to lambast copyright infringement when it happens to us, but it's very hard to be mindful about one's own use as well. It cannot and must not be rationalized that it happens the world over. Person A is doing it, person B is doing it, why shouldn't I? It doesn't make it right. It is a big deal. Now, especially now that we have some basis of knowledge about the do's and don'ts, you are aware of your rights, you're aware of what you should be doing, what you shouldn't be doing. It's rather incongruous to not follow the legal route, and it would be truly unfortunate if it didn't, which sort of resembles people's attitudes to the most inconvenient things like saving up on water or not littering. Everyone's doing it, why should I? It's not us that don't make a change, the change is not going to happen. So henceforth, be mindful about your content, take pride in your content, take pride in your creative abilities, strive to do things within the course of the law. And I guess it's pretty much it. My time is up. It's a little past 10. So if anyone's got any questions, now would be a great time.
Uh, so I had a question about creative. Sorry, yeah, the Creative Commons licenses. So like,
Yeah.
I intern as a social media marketing this thing. So like I have to
Alright.
create creatives on a daily basis. So it's not possible for me to always come up with graphics, like especially photographs myself. So I usually source it from the site which I'm using, but then
Yeah.
I also use the ones which have the Creative Commons licenses. So it asks it some mention that is required. So what I wanted to know is, like, on a graphic where I'm just using the image with a certain text, what is considered an appropriate attribution? Like if I add a link in the photograph itself, so like there's a feature that allows me to link the photograph to the link from where I've taken it. If I do that, is it enough, or does it have to be on the image saying that
So it's a very good question, and the fact that you're thinking about it, that you're already sourcing from Creative Commons, source goes a long way. It shows that regardless of the pressures on you, you are still looking to source, content responsibly. I would suggest at this point, do the best you can. Whatever I've mentioned so far is more of a proactive thing that needs to be done. Yes, you are doing something illegal, but it's you're holding yourself responsible. So simply including a link on the picture will go a long way than not including a link at all. So for the moment, I feel like that is enough of a good practice. But over time, if this becomes, a central tenet to your profession, always makes sense to like I said, spend a little extra money, register yourself with a paid content site that gives you royalty-free premium content that you can use no end, that you can truly exploit for your creative endeavors with a clean conscience and within the purview of the law. So to answer your question, for the time being, it seems like you're doing the most you can. Including a link on the picture would be more than sufficient for the time being, knowing that you're not, overtly doing something wrong. So that's a good practice, and I suggest you only try and improve on it over time.
okay.
Uh,
And the reason, like how I described, the reason that I'm using those images for will be considered commercial, right? So like, oh,
yes, if
would
you're using it for, if you're using it in the course of your internship, like you said, and if those creatives are going to be used by the client, if they go ahead in as part of a campaign or something, then yes, it is being used creatively. But then again, it would depend on, the person that owns the copyright. The fact that it's on a Creative Commons site demonstrates her or his intent for the image to be used in the first place. That's why it's on there. He's encouraging it.
right.
So the fact that you're using it and attributing its origins should work fine. It should work just fine for me.
Okay. Thank you.
That's a great question. What's the deal with blogs and websites like WordPress? Ooh, it's a little shifty. I'm not too altogether familiar with WordPress. I just wasn't able to get into it, but it seems like, if things are a little too easy, then there's always a catch. So I'm not too sure. Uh, Blogs, um, just like I guess putting your content up on social media would depend on how well you how the extent of the originality of your thought. Is it, like a personal narrative? Is it a personal diary of sorts that you're not lifting substantially from other sources? But if you are posting on something like a WordPress, it would be, and if it is your original content, then you've got nothing to worry about. You might have to worry about your content being infringed upon, because say you put up, say, the toolkit that I made available to you guys. If I were to put that up on WordPress, there's no guarantee that I would sort of accept that in time it's going to be copied n number of times, and I'm not going to be credited, and I will have no control over it. So I guess that's the deal with websites like WordPress. Any other questions, guys, on other practices that you can keep in mind? Any questions on the nitty-gritties of any concepts that you might be unfamiliar with, if you would need clearing up on?
So Sean, we will be circulating the toolkit that you have shared with all the 3 classes,
Yes.
and which is based on what you have done in the last 2 days. So that should be helpful to them.
Yeah. Ma'am, a student had, I
Yeah.
think, a student named Purva had a question. Go ahead, Purva.
No, Shakti, it was by mistake. Sorry.
Oh, right. You had me going there for a bit.
But
Okay,
there's
so
a
Sasha,
question in the chat box, Sean.
yeah, if you tweak an image and use it for a project, is it still illegal? No, as long as you tweak it with enough originality to make it something new, or because I mean, like I said, it's still in the course of education, so it's still protected from infringement to a certain extent. It's only when you start commercially exploiting it, passing it off as your own without acknowledging that you've taken inspiration or based it off something else, that it becomes a problem. So you, by all means, tweak the image all you want, but make sure that you either take permission from the person, if it is a copyrighted image, try and take permission, try and acquire a license, or tweak it in such a way where anyone would be convinced that you've put in sufficient the four benchmarks: skill, labor, judgment, and capital, which is not necessary, but at least skill and labor to make it into something that can be termed original, that can be termed different and new. Yeah. Great questions, guys. It's been really cool. The bunch of you that have been receptive, you've really processed and reflected on the concepts that we've spoken about. And I hope it does y'all some good. I hope y'all have learned a little bit of something and are able to apply this in your creative endeavors. Again, remember, just because everything's available free online, that doesn't mean it's free or legal to use. Take pride in your creative intellect, take pride in your abilities, and stay within the realms of the law. Is all I have to say. I can include. I'll just type in my.
Stop screen share.
Oh yes, sorry. All right.
So I could take a screenshot with the participants. That's all.
All right. All right. I'm just sending my email for people if they've got any questions.
Can we request everyone to switch on, or whoever is possible?
Very welcome, guys. Very welcome. Been a pleasure.
Thank you. Thank you so much. So there are a couple of windows. I'll go one by one.
I'm hold on the screenshot a bit. All right, I'm ready.
Trisha, Christine, Kiara, can you all please switch on?
Ma'am, I'm having very bad internet issues actually because I'm using hotspot.
Okay. Shloka, Shivani, are you around?
Yes, ma'am. So on behalf of the Department of Mass Media, St. Xavier's College, and the entire class present here, I would like to thank Sean sir for taking time out and conducting this session. The last 2 days have been really insightful and have given us a better understanding of intellectual property rights, and also how we as students and creators can make use of them and assume them and safeguard our own rights. So thank you so much, sir, for sharing your knowledge and experience with us.
You're very welcome, guys. It's truly been a pleasure. It's been really fun. I've really enjoyed fielding your questions. You guys are very creatively, curious, intellectually curious as well. And I wish you all the very best over your for the course of your studies. Do well, and I hope to be speaking to you guys soon sometime. So it's been fun.
Thanks, Sean. Thank you.
Perry ma'am's here. Hi, ma'am.
Hi.
Ma'am, I did that. I looked into that patent thing that